Hello everyone, welcome to Legal Darshan. In this video, we are going to discuss another case, which is case number 14. This is case number 14, Gita Hariharan and another versus Reserve Bank of India and another. It is a 1999 Supreme Court judgment. It is listed as case number 14 in the list of leading cases for AOR exam 2025. Okay, so as all other cases, this case is also available in the head notes. The head notes of this case is also available on the GSCR website. You may refer the head notes here. The head notes are in concise format so that you can have a quick grasp of the judgment. Now, this judgment deals with section 4 and section 6 of Hindu Minority and Guardianship Act, which we also called HMGA or HMGA, right? In our law school, we often use abbreviations HMGA, which is Hindu Minority and Guardianship Act. Now, this act is giving you all about Hindu guardianship, how Hindu guardianship works in country, how Hindu law governs the guardianship in Hinduism, right? Now, let's get to the query that was posed before the court in this case. In this case, what is happening? The parents of a minor child is registering a bank account before RBI. Okay, now what happens? They jointly applied for a bank account in the name of their minor child. Now what happens is that the mother and father both sign on the application of the minor's bank account. Later on, someday, the father of the child is not in town and the mother signs the document, but RBI rejects that signature, that authority of the mother, saying that no, she's not the natural guardian as per the Hindu Maintenance and Guardianship Act. He says that the RBI is contending that according to section 6 of the Hindu Minority and Guardianship Act, the term after means that once the father is no more, only then the mother will operate as natural guardian of the child. So court here in this case is interpreting the term father and after him the mother and is giving a new meaning to this definition. Now, when we look at section 6 of Hindu Maintenance and Guardianship Act, pardon me, we can find that section 6 is defining natural guardian for Hindus. Okay. Before that, we come to the definition clause. In definition clause, guardian has been defined as a person first who is in care of a person of minor, who is taking care of a minor person and also taking care of the property of minor. Okay, he's taking care of minor as well as the property of minor, and it includes a natural guardian, a guardian appointed by court, a guardian appointed or declared by will of the parents, either mother or father, or a guardian or a person who is empowered to act as a guardian by any act and or etc. Right? Now, natural guardian, this act is providing in definition clause C that natural guardian means any guardian mentioned in section 6. Now, when we come to section 6 clause A, it is saying that in the case of a boy or an unmarried girl, the father is the natural guardian of a Hindu minor. Here the word minor is written. In the case of a boy or an unmarried girl, the father is the natural guardian of the minor and after him, the mother. Okay, provided that the custody of minor who has not completed the age of 5 years shall ordinarily be with the mother. This is something we all know, that if a child is up to 5 years of the age, the custody by law stands with the mother. Now, next we come to guardianship. Now, guardianship here in Gita Hariharan's case, what is happening? Father is not available to sign the document, and in his place, the mother is signing the document, and Reserve Bank of India is rejecting the document, saying that no, because the father is alive, the mother cannot sign the document, because here after him means that the father has passed away, father is deceased, and therefore mother is taking the place of natural guardian after his death. The court here took a very progressive view, or we can say, because recently in the judgment we covered in the morning, Vishakha in 1997, court took a very feminist outlook to that judgment. Even in this judgment, we can say the court is taking a very feminist outlook. Now here, court is invoking few conventions. Court is looking at few articles in the Constitution of India. Court is looking at Article 14, Article 15. Court is looking at CEDAW. Court here is saying CEDAW is, we discussed in Vishakha's class, CEDAW is Convention on Elimination of Discrimination Against Women, right? CEDAW stands for Convention for Elimination of Discrimination Against Women. Now, this convention the court is invoking here, because of course India has ratified it in early 1990s. Now, court is saying that if a mother and a father both are parents to a child, then why would, in the basic absence of the father, you are denying the mother guardianship rights? If the father is, for example, you have to sign a document in Delhi, the father is not available in Delhi, father has traveled abroad, father has gone to America, Canada, father is in Mumbai, does it mean that mother cannot sign that document? So here the court are saying that if you violate that right of mother, you are discriminating her basis her gender also, right? So CEDAW here has been invoked, your Article 15 here has been invoked, and in this case the court held that, the term after him is thus, it is not meaning that the father should die and then mother will take the place as a natural guardian, but it also means, it can also be construed as in absence of father. Okay, so if the father is not available to perform his duty as a natural guardian for the minor child, the mother may also take that role and mother may also perform it, and nobody is going to say that no, the father is alive and mother cannot be a guardian, natural guardian according to the Hindu Minority and Guardianship Act. All right, so the court also said that this particular judgment, this particular decision will also apply to guardianship and yes, to Guardianship and Wards Act of 1890 wherever it is necessary. So it was held in the court that in section 19 of Guardians and Wards Act, it will also be applicable in the same manner, that if the father is not available, the mother in absence of the father shall be the natural guardian of the child, right? So Gita, Hariharan, and cases like Vishakha, Gita, Hariharan, all of these cases are taking a very feminist stance, taking a very gender equal stand. It is promoting gender equality. It is taking ahead the norms, that the rules that are contained in CEDAW, that is the objective of Article 14 or Article 15 for that matter. And these judgments mark as one of the pioneer judgments, one of the key judgments in the development of feminist jurisprudence in India as well. All right, so this was it for Gita Hariharan's video. The main bone of discussion, or main topic of discussion in this case, is section 6 of the Hindu Minority and Guardianship Act, where the term after him was interpreted by the court to mean, or to construe it, that in the absence of father. So absence may mean that the father is no more alive, and the absence may mean that father is not present there at the time of cause of action, right? So this is what was held in Gita Hariharan's video. I hope this is clear to you. I hope this is helping you. This series is helping you. So we will be bringing more cases to you in the upcoming 1 month. Please stay tuned. Keep watching Legal Darshan. And if you have any queries, any feedbacks, any doubts, anything you want to communicate to us, you may drop them down in the comment box below, or you may write it to me on my email ID, legaldarshan@gmail.com. Thank you, everyone. Have a very, very nice day.